Hello, welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading. Today, we are going to discuss the important issues appearing in the New Delhi edition of the Hindu newspaper dated 22nd December 2019. The news to be discussed has been presented on the screen, and timestamping for the same has been provided in the description box below. So let's start our today's discussion. The first news to be discussed appears on FAQ section on page number 14. It says, what connects the NPR, NRIC and Census? Now, amid this ongoing protest, specifically with respect to Citizenship Amendment Act and its link with NRC, this particular news has appeared in the same connection, explaining about National Population Register, National Register of Indian Citizens, and their connection with that of Census of India. So, let us understand these details as provided in this particular article. Now, the idea of National Population Register as well as National Register of Indian Citizens can be traced back to the Citizenship Act of 1955. Now, this concept of issue of national identity cards was added through the 2004 amendment. It says that the central government may compulsorily register every citizen of India and issue national identity card to him. Then it states that the central government may maintain a National Register of Indian Citizens, that is NRIC, and for that purpose establish a National Registration Authority. So, this act says that to maintain this particular register named National Register of Indian Citizens, the government must establish an authority or a body named National Registration Authority. It further says that on and from the date of commencement of Citizenship Amendment Act 2003, the amendment through which Section 14A was added, the Registrar General of India, who is appointed under the Registration of Births and Deaths Act 1969, shall act as the National Registration Authority. It further says that the central government may appoint such other officers and staff as may be required to assist the Registrar General of Citizen Registration in discharging his functions and responsibilities. And further says that the procedure to be followed in compulsory registration of citizens of India shall be such as may be prescribed. So basically, the central government is empowered to make rules with respect to NRIC, that is, with respect to conducting an exercise of registering every citizens in this country. So basically, NRIC shall be a subset of NPR. So primarily, the government will maintain a database known as National Population Register, as the National Population Register includes the residents. So out of those NPR, the government will find out that who are the citizens of India through this register. So whomsoever name appears in NRIC shall be considered Indian citizens. So this is basically the exercise as per Citizenship Act of 1955. Now this topic becomes important because as you can see in the year 2014 a question was asked in GS paper 2. The question read, two parallel run schemes of the government, that is Aadhaar card and NPR, one of the voluntary and other as compulsory, have led to debates at national levels and also litigations. On merits, discuss whether or not both schemes need run concurrently, that is both NPR and Aadhaar needs to run simultaneously. It further says that analyze the potential of the schemes to achieve developmental benefits and equitable growth. So this was the question asked in 2014. Considering the ongoing protest with respect to NRC, again questions may be asked whether the entire conduct of NRC in the entire country will have any developmental benefits and will it be a equitable growth story. So only time will tell that how NRC shapes into actual practice. So we understand that this topic becomes important from our examination perspective. So in your mains examination, this becomes a part of GS paper 2, specifically with respect to Indian Constitution, as well as functions and responsibilities of the Union and states, and also with respect to statutory and regulatory and other various quasi-judicial bodies, and also with respect to government policies and interventions for development in various sectors. So in this backdrop, let us understand what has been highlighted in this particular article. Now this article also mentions about census. So in this backdrop, let us go through certain basics about census. Census in India is conducted as per the Census Act of 1948 after every 10 years. It says that this act provides for certain matters in connection with taking of census. So hereby it mentions that central government to take census. So it says that the central government by official notification declares intention of taking a census in the whole or any part of territories to which this act extends. Further, Section 4A of this Act mentions that staff of every local authority to be made available for taking census. So it says that the central government has power to direct every local authority in a state whereby they have to make available their staff with respect to conduct of census in India. Now, Section 4 of this Act mentions about appointment of census staff. Here, the central government as well as the state government is empowered to appoint officers for the conduct of census in the entire country. It says that the central government may appoint a census commissioner to supervise the taking of census throughout the area in which census is supposed to be taken. And with respect to state government, it says that the state government may appoint persons as census officers with such designation as the government may specify or deem necessary. So both the central as well as the state government is empowered to appoint officers with respect to conduct of census in India. Now coming back to the article, this article has answered various questions with respect to NPR, NRIC, census and has also linked these three aspects with Aadhaar as well as Citizenship Amendment Act. So after having a basic backdrop to this article, let us go through each of the questions posed in this particular article. Now it's important to note that this entire topic of NPR was also covered in the October 2019 edition of Focus magazine. So in this aspect, we shall also refer Focus magazine in between and also some of the official websites of the Government of India whereby they have answered some of the FAQs with respect to NPR, NRIC, census, Aadhaar as well as Citizenship Amendment Act. So the first question is, what is National Population Register? It highlights that NPR is a database containing list of usual residents of the country. It's important to note that NPR does not constitute all the citizens, rather it is a database of all usual residents of the country. And its objective is to have a comprehensive identity database of people residing in India. Now, as you can see, this topic was also covered in the October 2019 edition of Focus magazine, whereby we had mentioned about NPR. Now, we mentioned this because the Home Minister of India had floated this idea of one nation, one card, and asserted that National Register of Citizens would be implemented across India. In the same address, the Home Minister also highlighted about the idea to resurrect National Population Register all over again despite successful implementation of Aadhaar. So he basically mentioned about three things, that is National Register of Citizen, National Population Register as well as about Aadhaar. So we mentioned about National Population Register. It says that NPR is a comprehensive identity database maintained by Registrar General and Census Commissioner of India under Ministry of Home Affairs. Now this again becomes an important aspect from your prelims point of view. Now this NPR is a register of usual residents of the country and not of the entire citizen and shall be prepared at local, sub-district, district, state and national level. Now we have already seen that NPR is being prepared under the provisions of Citizenship Act 1955 and Citizenship Registration of Citizens and Issue of National Identity Card Rules 2003. And it says that it is mandatory for every usual resident of India to register in the NPR. Now, why this registration is mandatory in NPR? The registration is mandatory because it is only from the set of NPR the government will take out or maintain a list of NRIC, that is National Register of Indian Citizens, as per section 14A of Citizenship Act of 1955. So this again becomes a very important point from your prelims perspective. And it says that as per section 14A of Citizenship Act 1955, it is compulsory for every citizen of India to register in National Register of Indian Citizens, that is NRIC. So the NRC which is being talked about amid protest is actually NRIC, that is National Register of Indian Citizens. It further says that the creation of NPR is the first step towards preparation of National Register of Indian Citizens. Now the question is that who is a usual resident as per NPR? So as per Ministry of Home Affairs, usual resident of the country is one who has been residing in the local area for at least 6 months or intends to stay in a particular location for the next 6 months. So here are two aspects. First is his past location and next is his intended future location. So the person must have been residing in the area for the last 6 months and must intend to stay for another 6 months in the same place. It further says that NPR is different from National Register of Citizens. It says that unlike the NRC, NPR will not only include citizens but will also include foreigners, as it would record even a foreigner staying in a locality for more than 6 months as mentioned here. And this NPR database will contain both demographic as well as biometric details, which will then be seeded with Aadhaar. So these details provided in NPR will again be seeded or connected with Aadhaar. It says that the government also plans to seed or connect Aadhaar database with updated NPR. So we find a connection here with respect to NPR as well as Aadhaar. It further says that this updated NPR database along with Aadhaar number will become the mother database and can be used by various government departments for selection of beneficiaries under their respective schemes. So in times to come, once the entire exercise of NPR is completed, this database will be connected with that of Aadhaar. Now the next question is that what is the legal basis of NPR? This we have already discussed, as NPR is a mechanism outlined in a set of rules framed under Citizenship Act of 1955. Now the next question is there any link between NPR and Aadhaar? Now we have already seen that the database collected through NPR shall be merged or seeded with that of Aadhaar. Now here you must understand that before the coming of Aadhaar into picture, NPR already existed, and once the previous UPA government brought the idea of Aadhaar, the entire question of NPR versus Aadhaar came into being. So here the question is not only the link between NPR and Aadhaar, but whether NPR and Aadhaar shall exist simultaneously. The answer is yes, they shall exist simultaneously. So it says that during the early days of NPR enrollment under the UPA, the Unique Identification Authority of India scheme for issuance of Aadhaar numbers was also concurrently on. And accordingly, there was a conflict between the Union Ministry of Home Affairs as well as with respect to UIDAI with respect to Aadhaar and NPR. So effectively, it was agreed that both databases, that is that of NPR and that of Aadhaar, will exist with different objectives and that each will use others' biometric data. That is, both will be seeded in times to come. Hereby it mentions that those already enrolled for Aadhaar need not give their biometric details again during NPR exercise. And at the same time, data captured for NPR would be sent to UIDAI for deduplication. Now this becomes an important aspect because whatever data shall be collected during NPR exercise shall be sent to UIDAI or for cross-checking of these datas. So effectively, this cross-check will weed out duplicate Aadhaar cards. It says that in case of discrepancy between Aadhaar and NPR data, the latter would prevail. So if there is any discrepancy between Aadhaar and NPR, then NPR would prevail and not Aadhaar. Now before going to the other questions discussed in this article, let us discuss about the backdrop to NPR. So the question is that when did this entire exercise of collection of data for National Population Register started? It says that the data was first collected in 2010 along with the house listing phase of Census 2011. So here we see a connection of NPR with that of census in India. So it says that these data for NPR were actually taken from the census of 2011. It further mentions that in 2015, this data was further updated by conducting a door to door survey. So this data for NPR was then further updated in the year 2015 through door to door survey. However, this entire exercise with respect to NPR slowed down because of coming into picture of Aadhaar. So after mentioning about this register by Home Minister of India, this has again gained momentum. It says that NPR will again be conducted in conjunction with house listing phase from 1st April 2020 till 30th September 2020. So this entire exercise of NPR will again be conducted along with the census of 2021, as this date is the first phase of census for 2021. Now another important point to be noted is that only Assam will not be included with respect to this exercise of NRIC, because recently NRC was conducted in Assam. Now another important fact highlighted in the Focus magazine was connection between NPR and Aadhaar, as this has also been highlighted in this particular article. We have already seen this, that the data collected by NPR will be sent to UIDAI for deduplication and issue of Aadhaar. So overall the NPR will contain three elements, that is demographic data, biometric data as well as Aadhaar number of a person. However, an important point to be noted is that a person who is registered under Aadhaar still has to register compulsorily under NPR. So a person cannot opt out of NPR even though they have Aadhaar. So after understanding this connection, let us also understand the objective of this exercise of NPR. It says that the objective is to create a comprehensive identity database of every usual resident in the country, and also to help in better utilization and implementation of benefits and services under the government schemes with respect to improved planning and security in the country. So this database will effectively contain demographic as well as biometric details. Further, it says that updation of NPR will provide solution to various problems facing the country, ranging from effective maintenance of law and order to efficient implementation of welfare schemes like MG Narega, food security as well as nutrition campaign. Further, updation of NPR will help in tracking criminal activities and better planning and execution of government schemes, as the NPR links biometric and demographic details of an ordinary resident, and this effectively makes NPR a comprehensive database of the residents. So after understanding these benefits of NPR and its connection with Aadhaar, let us go back to the article to find out what the article has to say with respect to NPR as well as NRIC. So it says that what will happen after the entire exercise of NPR is completed. As already mentioned, that after the conduct of NPR is completed, the government will weed out or come up with the National Register of Indian Citizens, and this will be prepared at local, sub-district, district and state levels after verifying the citizenship status of these residents whose name have been provided in NPR. And the conduct shall be guided as per the citizenship rules of 2003. So as per the rules, particulars of every family and individual found in the NPR shall be verified and scrutinized by local registrar. And in the process, details of those whose citizenship is doubtful will be entered with a comment suggesting that further inquiry is necessary. So from these NPR, a list of NRIC shall be conducted, and with respect to those citizens whose citizenship is doubtful, shall be commented upon with respect to conduction of further inquiry. So those families or individuals on whom further inquiry is to be done shall be informed about such further inquiry, and they shall be given an opportunity with respect to being heard by the sub-district or taluk registrar of citizen registrations before a final decision about their citizenship status is taken by the government. So the government will provide opportunity to those people on whom citizenship status is doubtful, and this decision shall be made within a period of 90 days. The next question is the NRIC step then complete after this? Answer is no, because after this, a draft of local register of Indian citizens shall be compiled. And such compilation shall be published in the official gazette to invite objections or claims for inclusion or correction. So basically, once this draft list of NRIC is completed, then such draft shall be published so that people can claim their objections or can come up for any correction in the draft NRIC. However, the time limit for any correction or inclusion with respect to draft NRIC has been provided at 30 days. It says that any objection or request for inclusion must be made within 30 days of the publication of the draft. And once any objection or claim has been stated to this particular draft, then such objection or claim shall be disposed of within 90 days. So after such issues has been disposed by the sub-district or taluk registrar, thereafter the entries in the local register will be transferred to the national register. So first there shall be a draft, then there shall be an entry made in the local register, after which such local register shall be transferred to the national registrar. Further, any person who is aggrieved by this exclusion can file an appeal to the district registrar within 30 days, and this appeal shall be disposed of by the district registrar within a period of 90 days. Now another important question is that what are the documents that would help establish citizenship? Now as of now, the government is not yet clear with respect to the exact details with respect to documentation. However, the government says that any document that shows date of birth, place of birth or both will be sufficient, and that common documents will be accepted, such as Aadhaar or passport. However, the government so far has not clarified on this common document. So let us wait for the government to clarify with respect to certain documents which would be necessary to establish citizenship. It then says that many state governments have said NPR would not be implemented. Is this possible? Now, as of now, this remains more of a political decision. But as per the Census Act of 1948, if this is conducted through census listing exercise, then it shall be mandatory for the governments to maintain a list of NPR. However, even to conduct NPR, staffs and officials are required at state level. So it is incumbent upon the various state governments whether to provide them these staff or not. So it says that as the house-to-house enumeration is part of the census operation, it is unlikely that NPR process can go ahead without state government cooperation or state government agreeing to deploy their staff for this particular purpose. However, census is in charge of the central government, and if the central government says so, then the state government has to abide by the central diktat. And this is also because census forms part of Union List of 7th Schedule under entry 69. Now this article also mentions about section 4A of Census Act, which we have also seen or also gone through, as it says that the central government can ask staff of every local authority to be made available for taking census exercise. So if the entire exercise is carried as part of census exercise of 2021, then it becomes mandatory for the state to comply with the census rules. However, it must be noted that some of these states who are denying as of now is not with respect to census exercise, but it is with respect to NRC, that is National Register of Citizens. Now the last question here is that what is the relationship between NPR and Citizenship Amendment Act? Technically speaking, there is no link between NPR and Citizenship Amendment Act. However, the Home Minister has said that after the Citizenship Amendment Act is passed, he will conduct NRC, that is National Register of Citizens, in this entire country. And this conduct of NRC with respect to providing documentation proof of citizenship has created fears mostly among the minority communities in India, as they fear that it is the intention of the government to exclude such minority communities from the list of NRIC. But on this, the government says that the minorities need not fear, and also because so far the government has not framed any particular rule or has not framed any particular law with respect to conduct of NRC in the entire country. So, considering the ongoing protest with respect to National Register of Citizen and Citizenship Amendment Act of 1955, this topic becomes very important for us to understand from an examination perspective. With this, let's move on to our next news discussion. The next news for discussion also appears on page number 14. It says, why is it taking so long to label fast food? What are the regulations on salt and trans fat in junk food? And why is the FSSAI draft still not a law? Now, this entire FAQ is based on regulatory threshold of salt, fat, trans fat, as well as carbohydrates on various junk foods. And this is because salt, fat, trans fat, and carbohydrates have high impact on health of a human being, including health of a child. Now, CSE, that is Center for Science and Environment, has conducted a research on chips, burgers, pizzas, and other fast foods and found that salt, fat, trans fat, and carbohydrate contents in these servings are very high. So, this entire article is about regulating these salt, fat, trans fat, as well as carbohydrates in these junk foods or fast foods. Now, it is in this regard the Food Safety and Standards Authority of India, that is FSSAI, had come up with the rules in 2011 to regulate these contents in these junk foods. And very recently, they have again come up with a draft law in 2019. Now, this study conducted by CSE has been opposed both by the industry as well as by some of the government officials, as they say that this might impact or hamper the food processing industry. So, in this backdrop, let us understand this particular article specifically with respect to recommended dietary allowance. Now, this topic becomes an important aspect from your prelims as well as mains perspective. In your prelims examination, this topic gets covered under general science as well as with respect to statutory bodies, that is FSSAI. Whereas with respect to mains, it gets covered under GS paper 3, specifically with respect to science and technology as well as food processing industry, along with GS paper 2 with respect to statutory and regulatory bodies, and also with respect to government policies and interventions for development in various sectors, including the food processing industry. So, on this note, let us understand whatever has been mentioned in this particular article. Now, as already discussed, as per a study conducted by Center for Science and Environment, which is a research-based organization, has shown that the total amounts of salts, fat, trans fat, as well as carbohydrates are well above the recommended dietary allowances. Now, this recommended dietary allowance is basically a daily ceiling limit on amount of salt, fat, carbohydrate, and trans fat intake. And this RDA is based on scientific consensus and has also been agreed upon by various experts bodies such as World Health Organization as well as by National Institute for Nutrition, which functions under the Ministry of Health and Family Welfare. So, as per this consensus, the RDA content per day must be 5 gram for salt, 60 gram for fat, 300 gram for carbohydrates, and 2.2 gram for trans fat. Now, with respect to trans fat, you must know that trans fat are of two kinds. One is natural trans fat and one is artificial trans fat or industrial trans fat. Now, these natural trans fat are found in meat and milk products, whereas artificial trans fats are partially hydrogenated fats, that is, adding hydrogen to liquid vegetable oils to make them more solid. Now, trans fat increases shelf life of eateries or products and also gives food desirable taste and texture. Further, the RDA, that is recommended dietary allowance, should not be more than 25% from breakfast, lunch, and dinner. And from snacks, these RDA should not be more than 10%. So this is the recommended dietary allowance with respect to salt, fat, carbohydrates as well as trans fat. So as per the recent study carried out by Center for Science and Environment has revealed that majority of packaged food and fast food items currently being sold in India contains dangerously high level of fat and salt. And this consumption of high levels of fat and salt causes obesity, hypertension, diabetes, and heart related ailments. Now, currently, the labeling of pre-packaged foods has been provided under the Food Safety and Standards Packaging and Labeling Regulations of 2011. Now, this regulation mandates that the companies must disclose energy, protein, carbohydrates, total fat, trans fat, as well as saturated fat contained per 100 gram, per milliliter, or contained per serve. So, as per the regulations, these pre-packaged foods must disclose the energy, protein, carbohydrates, total fat, trans fat, and saturated fat per 100 gram, per milliliter, or per serve. However, these regulations have not proved to be effective in promoting public awareness about health hazards of the pre-packaged foods. For instance, companies are not required to display these nutrients information on the front of the pack. Further, these companies are under no obligations or are not at all required to declare the salt content in these pre-packaged foods. Further, companies are also required to distinguish between veg and non-veg food through colored components. For example, green for veg food and brown for non-veg food. However, the CSE argues that the same has not been incorporated for the identification of food products having higher salt and higher fat contents. So, CSE has argued that pre-packaged food must highlight high salt as well as high fat contents in the front of the label, and accordingly has asked the central government to frame specific rules. Now, one of the FAQs here was what is the law on disclosing nutritional components? So, apart from the 2011 regulations on packaging and labeling pre-packaged foods, let us go through other laws as provided in this particular article. Now, in 2013, FSSAI constituted a committee to regulate packaged snacks or packaged foods. And this committee comprised of doctors, nutrition experts, as well as the CSE itself. Now, this committee recommended that any information on calories, sugar, fat, salt, and saturated fat must be displayed upfront on these packaged foods. Further, in the year 2018, the government came up with Food Safety and Standards Labeling and Display 2018 rules, and this was a draft law. This draft recommended that these packaged foods must have information on each of the nutrients such as salt, sugar, fat, trans fat, etc., which contributed to recommended dietary allowance. It also mentioned that if any of these nutrients or any of these ingredients which breached or which exceeded the RDA must be highlighted in red color. However, this particular move of this draft law was opposed by the companies because the companies believed that if anything was highlighted in red color, then the consumer would think that they are consuming something toxic or something which is dangerous for their health. And hence, all these companies came together and were against this particular draft law of the government of India. Now, the news highlights that these food companies had reservations mainly because they felt red signified danger and thereby fearing that this would give consumers the impression that they were consuming something toxic food. So, accordingly, these draft regulations never became law as it was opposed by all the companies at large. So, after this episode, another committee was formed headed by B. Sesikaran, who was a former director of National Institute of Nutrition. And based on this committee's recommendation, the new draft law, that is, the Draft Food Safety and Standards Labeling and Display Regulations 2019, has been prepared. And this draft law of 2019 has replaced sodium chloride with salt. Total fat has been replaced with saturated fat, and total sugar has been replaced with added sugar. Now, the CSE is against this particular draft law because it says that it dilutes the very purpose for which the draft law was formulated. So accordingly, the CSC says that this dilutes information on health harm posed by packaged foods. Further, this new draft law also exempts beverages less than 80 kilocalorie. So CSA says that in theory, a beverage may breach the added sugar RDA limit without informing the consumers as long as it was within the energy requirement. Now, added sugars are such sugars and syrups that are added to foods or beverages when they are processed or when they are prepared. And naturally occurring sugars in fruit or milk is not considered as added sugar. Further, this proposed draft law allows companies 3 years to adjust to these new laws. However, despite this fact, each of the nutrients RDA limit must be displayed on the front of the package. So this article says that even though the draft regulations have been out in public domain ever since July 2019, it is yet to become a law of the land. So after understanding all these aspects, let us go through the highlights of the Draft Food Safety and Standards Labeling and Display Regulations 2019. Now this proposed regulation suggests labeling the ingredients front of the pack, the point which we were mentioning earlier. Now this proposed front of the pack label has two parts. The first part declares that number of calories, saturated fats, trans fat, added sugar as well as sodium per serve will be reflected as first part, and the second part declares that per serve percentage contribution to RDA shall be mentioned. So it mentions both number of calories, saturated fat, trans fat, added sugar and sodium per serve, and also per serve percentage contribution to RDA. Further, it also defines a thresholds for nutrients such as fat, trans fat, added sugar and sodium, and if the quantity of these exceeds this threshold, then the nutrient will be coded with red color. Now this is the point which the companies are opposing as of now. Further, these regulations intend to make salt declaration mandatory on pre-packaged foods. Now this salt declaration will help people in taking informed choices, especially those who suffer from hypertension or are prone to high blood pressure. Now another benefit is that this provides for mandatory requirement for declaration of added sugar as part of nutrition labeling. So in the nutrition labeling, apart from the natural sugar, added sugar to the pre-packaged food content shall also be provided. It says that added sugar basically refers to sugar which gets added during the processing or preparation to improve the taste as well as shelf life of the products. Now, under the existing regulations, sugar is to be declared without specifying how much of it is added and how much is naturally present. So, with the declaration of added sugar, it will definitely make the consumers more aware with respect to their informed choices on buying these pre-packaged foods. Further, it will also help the children as well as their parents to know how much sugar intake is being taken by their children. Now, another significant development as per this regulation is that this regulation will make declaration of per serve contribution to RDA mandatory. So, as per the existing regulation, the consumer is expected to know only about the quantity of ingredients without knowing the declaration of per serve contribution to recommended dietary allowance. So, as per this proposed regulation, it will make this declaration mandatory with respect to per serve contribution to recommended dietary allowance. So effectively, this will make the consumer more aware about how much per serve they are taking certain nutrients such as sugar, salt or even fat or trans fat. However, this article highlights certain flaws in this draft regulation. It says that this regulation seeks to exempt certain categories of pre-packaged foods from following front of the pack labeling. So there are certain categories of pre-packaged foods on which the above mentioned regulation shall not be applicable. This categorization includes those packages which are less than 100 square centimeter, those beverages providing less than 80 kilocalorie per serve, and those beverages sold in reused bottles. So, in all these categories, the existing regulations shall not apply. So, this article highlights that in order to avoid the red coating on the packages, the food companies might start promoting or selling smaller packages so that they can conceal most of the information on those pre-packaged foods. Now, another flaw highlighted is that this proposed draft does not mention labeling of genetically modified food. It says that the earlier draft did provide for labeling of GM food, that is genetically modified food, but the present law or the present regulation does not mention of labeling of genetically modified food. So, if a pre-packaged food contains GM food, then such information shall not be provided. So this article says that GM labeling should be mentioned as it falls in the purview of packaged food. And another flaw highlighted in this article is that the proposed law allows companies 3 years to adjust as per the new law. So this article argues that these 3 years are way too high with respect to food industry. So the next point highlighted in this article is that why these draft regulations are opposed by food processing industries. It says that the industry argues that norms are unscientific and that packaged food is made to cater to the taste of people. Basically, the pre-packaged food industry is apprehended with respect to displaying of various information and it fears that this might lead to decline in their sale. Further, the package industry argues that immense quantities of junk street food such as samosa and other fried foods are consumed in the country without any regulation and the government basically is only trying to regulate the pre-packaged food industry. So there is an inherent unfairness with respect to regulating only the organized food processing sector. So this is also one of the arguments posed by the packaged food industry. And the industry, as already mentioned, is also opposed to the coding of red color since this would dissuade or this would prohibit the consumer from buying such products as red is generally considered as a sign of danger and the consumer might not end up buying such products. So these are the apprehensions of the food processing industries. Thus, this is a very informative article with respect to dietary contents which must be labeled on the pre-packaged food industry. Thus, this article becomes an important article from our examination perspective. The next news appears on page number 12. It says ICC, that is International Criminal Court, to probe war crimes in Palestinian territories since 2014. Now, there is a reasonable basis to proceed with an investigation. Now, the chief prosecutor of International Criminal Court has said that she wanted to open a full investigation into alleged war crimes in Palestinian territories. These Palestinian territories include the Gaza Strip, West Bank, East Jerusalem, as well as violence which occurred near Israel-Gaza border in 2018. Now, this move of Chief Prosecutor of International Criminal Court has been furiously opposed as well as condemned both by the United States of America as well as by Israel. Now, the Palestinians, however, have welcomed this particular step of ICC as long overdue after 5 years of the war in Gaza Strip. So, from a prelims perspective, this topic becomes important with respect to current events of international importance and in your mains gets covered under GS paper 2, specifically with respect to important international institutions. Now, the chief prosecutor has said that she was satisfied that war crimes have been or were being committed in West Bank, including East Jerusalem as well as Gaza Strip. As you can see in this map, this is the West Bank, this is the Gaza Strip, and it is surrounded by Israel. The chief prosecutor further said that before opening a full investigation, she would rather ask the International Criminal Court to rule on the territory whether she had jurisdiction over the Palestinian territories with respect to conducting investigation. Basically, she wanted ICC to declare whether she can conduct investigation with respect to these war crimes in the Gaza Strip, West Bank, East Jerusalem, as well as on the Israel-Gaza border. Now, this full investigation conducted by the chief prosecutor could possibly lead to charges against individuals. Now, it's important to note that ICC cannot charge sovereign countries. Now, the United States has opposed this move and has said that according to them, Palestine does not qualify as a sovereign state and therefore cannot participate as a sovereign state in the International Criminal Court investigations. So, after understanding these basic facts, let us also learn some of the important aspects with respect to International Criminal Court. Now, it says that the International Criminal Court may exercise jurisdiction in a situation where genocide, crimes against humanity, or war crimes were committed on or after 1st July 2002, and the crimes were committed by either a state party national or in the territory of a state party or in a state that has accepted the jurisdiction of the International Criminal Court, or whether the crimes were referred to the ICC prosecutor by the United Nations Security Council pursuant to a resolution adopted under Chapter 7 of the UN Charter. Now it says that as of July 17, 2018, a situation in which an act of aggression would appear to have occurred could be referred to the court by the United Nations Security Council acting under Chapter 7 of UN Charter. And this can be done by the United Nations Security Council irrespective as to whether it involves state parties or non-state parties. It further highlights that in the absence of a UNSC referral with respect to an act of aggression, the prosecutor may initiate an investigation on her own initiative or upon request from a state party. And this is the case with respect to this investigation into war crimes in Palestine, as the chief prosecutor of ICC has said that she wanted to open a full investigation into alleged war crimes in Palestinian territories. Now, this topic of International Criminal Court was also covered in the Prelims Compass magazine of international relations, and it has covered the topic under the head of international organization. It says that the International Criminal Court is a permanent international court which is established to investigate, prosecute, and try individuals accused of crimes of genocide, crimes against humanity, war crimes, and crime of aggression. So basically, it prosecutes individuals. It says that International Criminal Court was established by the treaty known as Rome Statute of International Criminal Court, and the ICC prosecutes individuals and not groups or states. Further, with respect to jurisdiction, it says that a state which is a member to Rome Statute is placed within the jurisdiction of International Criminal Court, and ICC may exercise its jurisdiction in situations where the alleged perpetrator is a national of a member state or when the crime was committed in the territory of a member state. Now, a state which is not party to the Rome Statute may decide to either accept the jurisdiction of International Criminal Court or not. Moreover, the United Nations Security Council can also refer a situation to the ICC, as we have already seen. That is, with respect to a crime, either the UNSC can refer the matter with respect to investigation, or the chief prosecutor can herself initiate a full investigation. It further highlights that there is no eligibility clause as to who can send a complaint to the ICC, and therefore it is open to individual, groups as well as states to refer complaints to ICC. But it highlights that referrals can be made either by a state party to the Rome Statute or by the United Nations Security Council. Now you must know that ICC is very different from the International Court of Justice, which is the principal judicial organ of the United Nations, and therefore is different from International Criminal Court. So please do not confuse International Criminal Court with that of ICJ, which is the principal judicial organ of the United Nations. Now, with respect to India, it says India has neither signed and therefore not ratified the Rome Statute on International Criminal Court. So India basically is not a member state with respect to Rome Statute. However, India considers the inherent jurisdiction of ICC as a violation of nation sovereignty. Therefore, India has insisted for having opt-in provision whereby a country could accept the jurisdiction of ICC by declaration specified to an issue and time period. Now, India as a country has its own reason to not ratify Rome Statutes. It says that India is resistant to accepting the inherent jurisdiction of ICC as it would be seen as being superior to Indian judicial system, and also remains hesitant towards the ICC as it can be used with political motives against India and its citizens with regard to Kashmir and also with respect to other matter of India's internal matter or India's internal affairs. So these are the aspects with respect to India and the International Criminal Court. So these points must be remembered with respect to ICC, as questions can be asked by UPSC in the prelims examination. With this, let's move on to our next news discussion. The next news appears on page number 9. It says manual scavenging has left 282 dead since 2016, and in this list, Tamil Nadu tops the list, followed by Haryana. Now, as for a question being answered in the Rajya Sabha, 282 people have died while cleaning sewers and septic tanks in India between 2016 and November 2019. And this is an official figure as per Ministry of Social Justice, and now sanitation is a state subject, and the people for cleaning of sewers and septic tanks are employed by local bodies. In this regard, states and union territories have been requested to ensure filing of first information report and prosecution in all cases of employment of persons for hazardous cleaning of sewers as per the provisions of the Prohibition of Employment as Manual Scavengers and their Rehabilitation Act 2013. In this regard, this particular news highlights about various figures with respect to deaths which have occurred in different states. Now, this topic becomes an important topic both from our prelims perspective as well as from our mains point of view. In your prelims, this topic gets covered under Indian polity as well as public policy and rights issues, as well as in your mains, it gets covered under GS paper 2, specifically with respect to welfare schemes for vulnerable sections of the population. Now, this figure highlights that states where large number of deaths were reported while cleaning sewers and septic tanks in the last 4 years. Tamil Nadu has accounted for maximum number of deaths at 40, followed by Haryana, where 31 deaths have occurred, followed by Delhi, Gujarat, UP, Maharashtra, Karnataka, and Andhra Pradesh. So the government must come up with certain important laws to ensure that these deaths do not take place when these people are cleaning our sewer tanks. Now, with respect to laws of manual scavenging, we have already seen that Prohibition of Employment as Manual Scavengers and the Rehabilitation Act 2013 provides for prohibition of employment as manual scavengers as well as rehabilitation of manual scavengers and their families. But the problem is that this particular law is not implemented in letter and spirit. Section 7 of this act says that it prohibits any person, local authority, or any agency to engage or employ people for hazardous cleaning of sewers and septic tanks. And violation of this particular provision of this act provides for imprisonment which may extend to 2 years. So, if any local authority, person, or any agency employs a person for hazardous cleaning of sewers and septic tanks, then they can be imprisoned for 2 years. Further, Section 13 of this Act provides for rehabilitation of such persons who are identified as manual scavengers by any municipality. However, it says that the law is not properly enforced and people are forced to do manual scavenging still in India. So, it is the responsibility of all the state governments to come together and ensure that the menace of manual scavenging finally ends. So it says that what can be done to ensure that these deaths do not take place. So the law on manual scavenging must be ensured in letter and spirit both by the center as well as by the state governments. And in this regard, no person, agency or authority shall employ people with respect to manual scavenging. Now this entire process of scavenging or cleaning of our sewers and septic tanks must be done using scientific process or scientific and mechanical ways. So it says that local authorities must find resources to employ machines for cleaning septic tanks and sewers. In this regard, Swachh Bharat Abhiyan can play a major role, as it says that the Swachh Bharat Abhiyan should make expansion of sewer network a top priority and come up with a scheme for scientific maintenance of tanks, as it will also help in ending manual cleaning of these septic tanks. Further, the two components of Swachh Bharat Abhiyan, that is Swachh Bharat Mission Rural as well as Swachh Bharat Mission Urban, both of them must look into the issue of sanitation and use funds available for SBM with respect to providing mechanized way of cleaning septic tanks. So it focuses heavily on finding scientific and mechanical ways to clean septic tanks in India, as it says that mechanized cleaning of sewers and tanks will reduce inequality, especially for such communities who have been traditionally involved in manual scavenging. So it will give relief to all those people and their communities who are involved in manual scavenging since ages. So effectively, the government must ensure that persons or people do not get employed with respect to scavenging, and the work of scavenging must be done by machines or through some scientific ways. Now, after our discussion, these forms your practice question for the day. What you can do is to take a pause of 5 seconds. First, which of the following countries faces Mediterranean Sea? Options are Lebanon, Israel, Turkey, and Libya. Now, questions are asked by UPSC on world maps. So, to see both these maps, as you can see, Israel as well as Lebanon faces Mediterranean Sea. With respect to Libya and Turkey, they also faces the Mediterranean Sea. So in this, all the options are correct. So the question is select the correct answer using the code given below. So here the correct answer is D, 1, 2, 3 and 4. Question number 2. Consider the following statements. First, National Register of Indian Citizens will be made out of National Population Register, that is NPR. Yes, this is correct. Second, NPR will comprise of only citizens and will not include foreigners. No, this is incorrect as NPR will include residents. So here the question is which of the statements given above is are correct. So here the correct answer is A, that is one only. Question number 3. Which of the following is our principal judicial organ of United Nations? Options are International Criminal Court and International Court of Justice. So we know here the correct answer here is ICJ, that is International Court of Justice. So the question is select the correct answer using the code given below. So here the correct answer is B, that is 2 only. With this, we come to an end to discussion of today's newspaper. Let's move on to the question for the day.